Exactly a year ago, the ORF team was in the Columbia University campus at our Tech Futures event. A lady's voice came through the room, loud and clear. Quote, "It's better to be asking who has the right to data rather than asking about ownership of data. Who's using it? Who's processing it? Who has access to it?" So I looked up and saw the voice belonged to Mishi Chowdhury. She's a technology lawyer who practices both in India and the US and legal director at Software Freedom Law Center. She's back with us today to speak broadly about 4 topics: WhatsApp traceability, antitrust, and the lurch towards big tech regulation, the gold standard via Europe, and finally, US and India tech policy comparison. So all that is on the rundown for this Sci-Fi Times Square fireside. Mishi, very warm welcome to you.
Thank you, Nicola, and very glad to be here and join you in this conversation.
So Mishi, I'll start with this ABC triangle nightmare scenario on WhatsApp. A sends a message to B, which is tagged as coming from A. B decrypts that message, forwards it to C, who then receives it with the included tag identifying A. And then he or she decrypts it in his turn, his or her turn. If C finds the message disturbing, they can complain to law enforcement authorities and so on. You know where I'm going with this. So that pending petition, this speaks to that. There's a narrow definition of encryption, and the destruction of the privacy encryption was designed to protect. How should we think about this?
Sure. I think the example which you picked up is something which I was describing in a litigation. There is a court proceeding which is currently pending in the Indian Supreme Court. And that was transferred from various courts, and that petition required that Facebook, which is the owner of WhatsApp, they make all WhatsApp messages traceable to their originator, and that was supposed to happen through the linkage of identity information. My view, of course, of the petition is that, and it should hardly be necessary to say it, is that it should be just dismissed as an affront to our basic constitutional freedom, which is right to privacy. And the example you have picked up is an example which one of the submissions by an expert had happened. There are a lot of people who are invited, very, very smart people, much smarter than I am, from IITs and various other technology researchers. And their view was the example which you provided. Now, the example is, again, to repeat, if A sends a message to B, a message that B then forwards to C, then because Facebook cannot see what the content of that message is. So we cannot tell what B sent to C, which is a forwarded message. Was it originally written by A, or is it something else, or is it modified? Now, the demand for traceability means all the security of all these communications will have to be broken. So Facebook in 2016, WhatsApp, I would say, WhatsApp in 2016 enforced and rolled out something called end-to-end encryption, which means if Nicola and Mishi are talking, then your messages to me are end-to-end encrypted. There is metadata available that your phone number and my phone number might be available, but what the content of that message is, that is not available to anybody, including WhatsApp. And that is what the sanctity of private communication is. Yes, you sent a message to me, you used some messaging platform, but you and I should be able to communicate freely. We may have something nice to say, we may have some recipes to exchange, but we might also have some sensitive information. So the first thing is that the tendency to say is, why do you need to talk privately? What is there to hide? As now it has been popular to say, I don't believe in free speech and expression, as if because I have nothing else to say. Or why do you shut the door when you use the bathroom? What do you have to hide? Those kind of arguments are so churlish and so far behind that it's not even necessary to address them now, because that's not what we are talking about. You may have something to hide, you may not have something to hide, but just the very fact that someone else can read it changes our behavior. And as human beings, we would just like to have sanctity of communication. And that sometimes could also be that I want to talk to my father about something which I may not want to talk to my mother about. And that doesn't mean we're hiding something big, it's just what we want to do. Just because you said that A sends a message to B and it is tagged as coming from A, B decrypts the message and then forwards it to C, who receives it with this tag identifying A. Now, C has done something which A had no idea about. It was not even intended for that person. So we are trying to break everything. And the submission said, you can go and sue this person. If you've ever dealt with the Indian litigation or Indian courts, saying that is basically saying, I don't believe in your rights, stop wasting my time. What we believe is in some blunt solution because we just think there must be a solution.
Here's another hot potato. So you've seen this, right? India, along with the Five Eyes Intelligence Alliance and Japan, wants companies to build backdoors to end-to-end encrypted platforms for access to law enforcement agencies, etc. The statement's just out. How do we think about this?
The statement to me says that despite all the platitudes about, oh, we believe in privacy, we believe in everybody is telling us that cryptographers don't understand cryptography, but the spies and the politicians do. It's not privacy versus security. It is always security and security. If you are going to take away and build backdoors, then everybody who works in the area, when all computer scientists, all cryptographers tell you that we can't build it for James Bond, a backdoor, and then expect that people who are going to use ransomware attacks, they are not going to use that.
Now, on this side of the Atlantic, Mishi, where we both are, after years of calling big tech too big, finally there's this 450-page report after 15 months of investigation that's just dropped. Given the spirit of antitrust up until now, where is this headed? This again comes just before the election, so nothing much is going to happen this year for sure.
Yeah, I would say I would agree with that statement. But going back to the report, I would say that antitrust, at least in the United States, for the past few decades, has mostly concentrated on consumer protection. And they have mostly worried about whether the consumers are getting a fair price or not. It is not about oligopolies and the power of the companies. And tech escaped that mostly because the products are free and because it is about data and targeted advertising and surveillance capitalism, which happens. So to come under that radar was difficult. And that's why it was possible either to just gobble up competition or try to copy features shamelessly, like Facebook does for every new startup, which they can't actually acquire. And or Amazon becoming the behemoth it is becoming. So, other than the European Commission, I don't see another jurisdiction which actually does anything with its antitrust regime and tries to put a brake on it. But antitrust also, or these such regulations, take time, litigation, and a lot of effort. And not many governments were willing to do it. And it also changes with administration. The current administration says one thing one day, does something different the other day, and are run on women fancy, not in terms of the actual position of law. Whether you see the executive order, which is issued after Twitter started putting at least some flags about the statements of the current president, or the push to give FCC the jurisdiction of amending Section 230 of Communication Decency Act. All of these seem to be just bloviating and not really based in law. I would say that the report is exhaustive, and one does need at least some semblance of an actual antitrust law which works with time. So, but that is only to see what the next Congress would be and how that gets enacted.
European lawmakers have long outrun Americans on privacy regulations. They've now begun drafting, in fact, a series of new laws aimed at limiting the anti competitive practices of major tech companies. What can a quintessentially European approach to tech teach the rest of the world?
For now, European Union is the only place where we have seen at least an emphasis on people's rights. And we've also seen that the regulation is appreciates the fact that you and I don't have time to read every term and condition that the company is going to tell us. They have watched how users behave, and that's thereafter they have come up with regulation. So the consent, when it is informed consent, does not mean, and in the European Union, you can find if you're not able to give a informed consent, then they recognize that fact as they do as an employer-employee relationship. And American way of doing this has been mostly go self-regulate because otherwise you won't be able to innovate. Um, so because Europe has been thinking about from the perspective of the users to a large extent, and they are the only ones who've had an omnibus legislation. So that's why we gravitate towards thinking of it as the standard which democracies can at least endeavor towards achieving. Um, then there are big success stories like the People's Republic of China, where even basic human rights and freedoms don't exist. So the platitudes and various claims can be made by them, but nobody takes that seriously, of course. Um, US has sectoral regulations to a large extent, but because it is sectoral, there is enough room for a lot of things to just slip through. We are seeing, of course, a big demand for an omnibus legislation to talk about privacy as well. I think I would agree that uh, users also have become far more sophisticated and smarter about their own rights and are demanding better products. And that's why the conversation started with this WhatsApp end-to-end encryption thing. And and you yourself ended with the last comment on it is that if police gets hold of your device, then all bets are off. And users are now thinking about this, that they don't even know when a very eh, a regular looking message can be interpreted and provided out of context. And once it is flashing on TV screens, it can mean whatever other people provide the context for it to. So users are demanding better products. There is a lot of emphasis on how our data is processed. The emphasis on data driven economy is going one way or the other. So obviously the discussions are much more knowledgeable than they used to be. So we would say that it is moving towards that. And Europe has taken it at least a little more seriously so far. So everybody looks up to them. And I don't think that's a bad place to look towards because Europe also has had the experience, um, unfortunately, during the Cold War period of what watching everybody and monitoring everyone's movements does to people, or even during the Second World War, how othering one kind of people and using technology to make to cause something um, which is inhumane to the extent of a Holocaust, what that does. So they have the historical context and they are putting in the work.
You've worked in two geographies, and that's a superpower in and of itself. I've worked in the US and India too, and the context that it gives you and brings to your work is just phenomenal, right? So, based on all of your real world experience of law in both these geographies, can you kind of compare and contrast the India and US approach to data protection?
India has been both a pioneer in the human costs and benefits of social media and in the encounter between the new forces and the law. And before even anybody else started paying much attention, India could present to you, it's like a petri dish. I have borrowed it from somebody who said that India and US are fine. Watching the same reality TV show, India is just always 2 seasons ahead, which is true. And In the past few years, Indian tech policy has changed rapidly and arbitrarily um, in its attempt to serve two conflicting goals, I would say. One is to encourage innovation, and the other is complete control of the public discourse. And history is witness to the fact that innovation happens where policies impacting businesses and people are certain and predictable, and the freedom to think is expressly protected. Um, so during the pandemic, uh, our organization has been so busy because every week there is some new regulation which the government of India is issuing. And it's amazing that we understand large democratic governments have a lot of various factions and ministries and everything, but it seems they never talk to each other. And it also is surprising they don't even read their own papers from the same ministry. So one week they want to regulate AI. The other week they want to tell you how data driven economy means non personal data framework has to be done. Then again, they want to tell you how right to privacy is going to be interpreted. Health has now complete different framework in terms of technology. And they are very concerned about privacy and data protection and security. And it's laughable. It's coming from a government which cannot even be bothered to really pass a data protection legislation. Having said that, I don't think that I have all my hopes in a legislation, because I am a realistic lawyer who actually practices in the court and sees how law works. And technology is too fast for us to be told that courts will solve all our problems.
Hey, you
So,
must be seeing a lot of wild and wacky stuff in the courts, right? Tell us about it.
so uh, So I will say that something which has happened to me last week is Google v. Oracle, a case which has been going on for over a decade, has reached the US Supreme Court again. And we have filed an amicus brief in that case. Um, and this is the second time we are filing it, because it's the second time it has come to the Supreme Court. And on last Wednesday, October 7th, there were arguments which were being conducted by phone. So I was listening to those arguments. And fortunately, unlike the Indian Supreme Court, where days go by and reams of paper have to fill, in the US, everybody just has 30 minutes to argue. So, and I was listening to this argument and I thought, so these are the smartest people ever, and they are still struggling to understand how copyright law works. And that has been around for such a long time. And they have had the best people help them understand what the issues are. And several of the justices kept asking one question, that 83 computer scientists filed this brief and said, if we don't do it, the skies will fall. And they were questioning the lawyer, do you think the sky will fall? and and I was just sitting there and I'm like, when a court decides some matter, it is very fact specific, and it is only deciding one controversy, but it has an impact on a very large industry for several years to come, and that can determine the directions in one way or the other. In the Indian courts, I have seen fantastic claims made, right from first, Indians don't have a right to privacy at all, to the kind of claims to say that Aadhaar data is protected because there are 10 feet high walls to protect them. And also these claims about there is terrorism if you allow everybody to use anything on the internet. And to India being the capital of internet shutdowns in the world, and Kashmiris being devoid of internet for more than a year, and the government's council making a claim that everything is fine, and why do people actually need internet? And there is a lot that happens. Unfortunately, these are complicated matters, and the courts are expected to do and learn a lot. And technology is way ahead, and law is anyway, even in normal days, trying to catch up with the developments. But with tech, there is such a vast gap that general courts, the generalized courts, are not going to be able to decide things for us. And everything ends up there. And it is a disservice to not only the general public, but it is also expecting a lot from the judges. When the government regulates, one would think that, oh, it should be simple, easy to understand, and predictable, and not written to favor few companies, or not written to favor only the government. But that's not what we see. And then one wonders where the motivations are.
Knowing doing gap. Mishi Chaudhary, thank you so much for your time.
Thank you. Thank you for having me. It was a pleasure.